Good afternoon, everyone. Welcome to our webinar on required and recommended policies. Do you have them and are they up to date? My name is Alina Gilbert. I'll be presenting the webinar today. But as always, before we start, we are going to go through a few housekeeping items real quick here. So first and foremost, if you have not been to any of our webinars yet, you should be looking at your screen and primarily see the PowerPoint, the slideshow. And off to the left is me. Hello, this is me. And off to the right is an icon that's labeled chat. So that's what you're going to use to type in questions. And we will get to those at the end of the program, time permitting. We have a lot to go through today, and I'm going to try very hard to get through everything and leave some time for Q&A, but I can't promise anything because there's just a lot of information to get through. If you're having any audio or video issues, there is a little button at the bottom of your screen that says audio or video issues, question mark. Click on that. It takes you through a series of steps, and hopefully that will resolve the problem. This webinar will provide you with 1 CMCA credit, assuming you stay on through the end, and it will be emailed to you within the next 24 to 48 hours. However, please, please, please either save or print the email with the credit so you have it, or save the actual certificate as a photo in your computer. There's some new stuff going on with the provider that basically the certificate disappears after 30 days. So please do something with it so that you retain it. Otherwise, it's going to go bye-bye in 30 days. As a reminder, we are recording today's presentation and it will be available on our YouTube channel. So if you have anyone you know who wants to watch it because they couldn't attend today, just let them know it's on the YouTube channel. You cannot get credits by watching it on the YouTube channel, but you can watch it if you are interested in the topic. And finally, last but not least, there will be at the very end, there will be a little pop-up questionnaire asking you about the class and about me as the presenter at the very end. If you have time and you are willing to share your thoughts, please do so. We always appreciate it. It helps us, it helps us make our programs better, and it helps us know what you want and don't want and what you're looking for and not looking for. So any feedback you provide is very much appreciated. So without further ado, let's go ahead and get started. We're first going to go through all 9 required policies. And they are all listed here. We're going to go through each one separately. But these are all required by Kiowa. They apply to all communities regardless of when they were created. So if you're looking at this list and you don't think you have one or more of these policies, I would encourage you to reach out to the association's legal counsel, because if you don't have all 9, you're technically in violation of the law, which exposes both the association and possibly individual directors to liability. So just be safe, make sure you've got all of them. All right. Now we'll go into each one and we can talk about what they contain and what they're for. So if you attended last week's webinar on the legislative update that Amanda Ashley presented, you will have learned about all these new things that have to be in collection policies as of October 1st, 2025. And I will not go into a whole lot of detail on that because we're just going to talk about in general the collection policy, but I do want everyone to be aware that policies are required to be updated before October 1st, okay? So if you don't have that in the works yet, I would recommend you go to your attorneys, whoever they are, for the association and ask them to update the policies. And I would do it sooner rather than later, because once you get close to October 1st, that's when like all the stragglers start submitting requests, and then the attorneys get really bogged down and they won't be able to give you a turnaround time that's too quick. So you want to make sure you have it, the requests in on time. Anyhow, the collection policy is intended to set forth a process that is utilized by the association when homeowners do not timely pay their assessments. All right, so Kiowa says you have to have, your policy has to have certain information, and it has to have the due dates. It has to tell you when you as an owner are past due, what kind of late fees and or interest is being imposed, return check charges. You have to offer, as you probably all know, a repayment plan, 18 months. You can't make it, you can't require it be shorter. It has to be at least 18 months. You have to allow $25 per month payment, and typically that's not going to pay the amount due, but you can have a balloon payment at the last month of the payment plan. So that's old. You have to have a provision on application of payments. In other words, when a homeowner does submit money, if it's not the full amount owed, how do we apply that sum to what's owing? And notices. So if you recall, we've had last year, 1233, we had to, we now have to provide notices of the delinquency to owners by certified mail, and then 2 of 3 options, right? So those 3 options are and were email, a phone call, or a text, which means we need to have either a phone number or an email address or both. And for the longest time, we were very unsure as to what would happen if an association, despite trying, could not get that information from a homeowner. Was it allowed to just send notice by email if that's all they had? Well, we still don't really know the answer to that question, because I'm not aware of any cases that came up where this was a challenge. However, our new legislation, which was House Bill 1043, it does provide us with an answer, and it says if the association does not have this information, it can substitute by sending the notice via snail mail. However, the association has to periodically attempt to get the information from the homeowners. So this is actually, for once in a blue moon, something that helps us. It clarifies what we as associations can do if we cannot get their email address and or phone number. The other thing that HB 1043 added was some additional information that has to be provided in the notices. For example, you have to add certain information about how the owners can get their ledgers, that their unit may be sold at an auction if they don't pay, and you also have to add a mention of that there is available information from DORA, from the DORA website, that they can utilize. The other part of this is foreclosures. And now we have an addition to the foreclosure requirements, and that is owners have to receive a notice of their right to credit counseling through DORA. And ultimately, that means if they take that on, the association has to postpone its foreclosure efforts. Now, it could be 6 months, they can ask for it to be longer, but generally that's what it means. So those are kind of the latest and greatest things we're seeing with respect to collection policies. So if you don't adopt it, if you have, or you haven't updated it since last year, what is the consequence? The consequence is you can't move forward with collection actions. Your lien is going to be no good. You won't be able to do anything with it, and you won't be able to submit anything over to the attorneys or any collection agency, because you will not have followed the requirements of Kiowa. So it's super important that you have your policy, but also that you update it before October. All right, let's move on. Enough about collections. Enforcement policy. This is another big one. Thank goodness we didn't have any changes to it this year. So yay, but I think we had quite a bit of changes when we had HB 1137 a couple years ago, which basically turned the process upside down on its head. So the enforcement policy is what? It is the process utilized by the association when an owner fails to comply with either the covenants, the rules, policies, etc. And Kiowa says that your policy has to contain obviously certain things, just like your collection policy. It has to have a process for how the association is going to investigate the facts if they receive an allegation of a violation. So what are you going to do to look into this? How are you going to independently confirm or try to confirm that there really is a violation happening? There has to be provisions that talk about notice of the violations, the alleged violations, and homeowners' opportunities for a hearing. You have to have a fine schedule, but one of the things 1137 changed is it said you cannot impose a fine that's greater than $500 total for a single violation. So that means you can impose 2 fines of $250 or 3 fines of $200, $200, $100, however you want to do it. But ultimately, for the same violation, it cannot be more than $500. Now, this doesn't apply when we talk about like health and safety violations. Those have their own process. Those have like a 3-day notice that you have to send. And all of that should be in your policy. If you haven't had it updated in the last couple of years, I would encourage you to have your attorneys review it and make sure that it is either up to date or that it needs to get updated to comply with House Bill 1137. Okay, there also has to be mention of what kind of information is going to be in the notices. Again, this is something that has been a requirement since 1137. Couple of things to keep in mind is, we now have a requirement that you have to send at least 2 violation notices, giving the owner 30 days in each violation notice to come into compliance. You have to send the second letter within 7 days of when you sent the first letter. So there's some very specific timelines here that have to be followed. I know that this has been around long enough that I would suspect most have a compliant policy and you're following these processes. But if this does not sound familiar to you and you're not sure whether your policy has all this language in it, have your attorney check and make sure you have an up-to-date enforcement policy. Because what is the consequence if we don't have one? You're not going to be able to enforce. You're not going to be able to get to court because you don't have a compliant policy. You're not going to be able to impose fines or collect fines because you don't have a compliant policy. So the consequences are pretty grim for not having an enforcement policy, just like the collection policies. That's why I like to talk about these 2 policies first, because they probably have the worst consequences of not being adopted. All right, next, conflict of interest policy. And this is really intended to be a conflict of interest for directors, and it's conflicting interest transactions, which is defined in the Nonprofit Act. And although we have a lot of situations that we call a conflict of interest because they smell bad, so to speak, they don't sit well with us, a true conflict of interest is defined in the Nonprofit Act as something that involves a monetary benefit to the director. So specifically, what it says is if the association has a proposal for work from a company that the director, the interested director, has ownership interest in it, they are like there's a board of directors and they sit on the board of directors, one of their very close relatives has an ownership interest in it, those are all considered conflicting interest transactions. So that needs to be defined in your policy as far as when a conflict is going to exist. Nonprofit Act also says, hey, director, you have to disclose this conflict to the rest of the board before they vote on anything. So we need to have a process for that disclosure in the policy. Again, the statute says once the director discloses it to the board, then you have to have a majority of disinterested directors approve it. So it basically means disinterested directors are all the board except for this one director who has that ownership interest. Can this director vote? Technically, the statute does not prohibit the interested director from voting. However, your policy can say that conflicted director does not vote. It doesn't matter because ultimately the approval that's needed is a majority of disinterested directors. So hypothetically, we've got 5 directors on the board. We have 1 director who's conflicted. So now we've got 4 disinterested directors. That means we need 3 of them to say yes to the proposed transaction before the board can lawfully sign on for it, so to speak. Statute also has one more thing that always strikes me as weird and odd and not really a real good way to handle things, because the statute also says if the interested director fails to disclose their conflict and the board goes on to approve this contract, it's not voidable. It's not automatically void. What it is it stays in place if it is fair and reasonable to the association. So a board member can lie, they can not disclose the truth, and then after their contract is signed, the board member can say, haha, I'm an owner of this company and I'm going to be making some money. But assuming the contract as far as pricing is comparable to what other bids were and it's comparable as far as the work description, the association won't be able to say, we're terminating this contract. They got to go through with it, even though the director did not disclose it. So that always kind of annoys me because I don't think it's a very good provision to have, and I think it almost invites dishonesty, or at least not full disclosure. But that's me. Adoption and revision of policies. I know, right? We're talking about all these policies. So this is a policy on adopting policies and modifying policies. This also includes rules and regs, resolutions, those types of things. The things that are adopted by boards, not things that are approved by homeowners. So this policy essentially needs to include language that talks about basically the process for adopting it, but also what kind of notice and comment capability the homeowners are going to have. So a lot of policies have language that say that before you can adopt a new rule or update your rules, the board has to send the update to all its homeowners and give homeowners 30 days to comment on it, and only after that can they adopt it. That is a horrible provision that unfortunately many policies still have. What it does is it ties up the association. It doesn't allow it to update its rules in a timely fashion. You're kind of stuck waiting for 30 days. So that's a problem. But if you have that language, you need to make sure you know that you have that language and that you follow that language, because anything you adopt that doesn't follow your adoption of policy is going to be subject to challenge. So if you haven't looked at yours in a while, pull it out, look at it, know what it says. If it has that horrible 30-day language, The good news is you can still modify it. The board can modify it to have something less strenuous. What I like to see in these policies is something that says that the board is going to add the item, the amended rules or whatever, to the agenda, to the board meeting agenda, and homeowners can attend the meeting and comment there. And that way you don't have the lag of having to wait 30 days, but there's certainly other ways of doing it. And so the board can amend its current policy to have a more flexible or, more reasonable approach to this. But before you amend it, obviously you're going to have to go through that 30 days one more time because your current policy does require it. So all I have to say is just please pull out that policy. Make sure you're following it with respect to your rules and your regs and policies resolutions. Because if you're not, again, it could be subject to challenge because you failed to follow your own set of rules for that. Okay. Inspection of records policy. So this is one that was, I think I want to say 2014 or so is when it needed to be updated last. So if right now you have a policy that's older than 2014, it's probably not compliant with the current version of Kiowa. The records provisions were rewritten way back when, and there are some very specific things in the statute now that define, they basically create an exhaustive list of what is considered an association record that is open to inspection by homeowners, okay? And the statute pretty much says, below is the list of all records that are subject to inspection by homeowners. So it's pretty clear on its face. And anything that doesn't fall within that list is technically not a record that needs to be provided to homeowners. Now, within that, and once you have this list of records, there is also the following provision in the statute says, however, here's a list of records that may be withheld. And there's some overlap in that provision with the records that we just named as being available to homeowners. So basically they're carving out some exceptions to the documents that were just listed. The next section says, oh, and here are the records associations that you must withhold. In other words, even if you want to produce this to the homeowners, you can't do it. And these are things, such as, personal identification information, account information, someone's driver's license number. If you have it, someone's email address or a phone number, you can't produce it without a written permission. So when this first came about, there was a big to-do because associations were producing these contact directories for their homeowners, where they basically had all the homeowners. They had their phone number if they had it. They had their emails if they had it. And they didn't ask for permission to publish this. And obviously, since the law changed, can't do that anymore. You need actual an affirmative written permission to be able to have that information disclosed. So anyhow, the records disclosure and production has changed significantly since, we first started doing this. And the policy has to include certain things. You have to identify what those records are that are subject to inspection. You have to give the homeowners a process explaining how they can request the records, okay? You have to disclose what kind of costs we're looking at for copies and the timing within which they will be provided. Now, the statute does speak to a lot of this stuff. And so one thing that's changed is we used to be able to, have homeowners fill out a form for records, which we can still do, but we used to put in the form, reason for request. What do you want to use these records for? Because we wanted to make sure they weren't using it for their pizza delivery business, right? Well, we can't do that. Since 2014, we have not been able to do that. So if you're still using a form where you're requiring homeowners to tell you why they want the records, you are violating Kiowa. You cannot do that. And the reason is, it's just a little bit of funny history, is because we had boards where homeowners would say, I want to see the financial records. The reason I want to see them is because I think the board is embezzling money. Well, the boards would say, well, we're not embezzling money. How dare you? We're not giving you those records. That's not a proper purpose. Well, actually, it was a proper purpose, but you had these boards that were like all of a sudden, you know, becoming these guardians of records, and they got to decide what was a proper and improper purpose. So that obviously somebody complained to the legislature, got their ear, and so lo and behold, we can't do that. Okay? So you can still require them to fill out a form, but you can't ask them why they're asking for the records. However, you can have them sign it and attest that they would only be using it for association purposes. What if we fail to follow our inspection of records policy? There's actually some fines that a homeowner can seek against the association. I believe it's $50 for every day that the association fails to turn over the records. I believe there's a cap of 500. But essentially they could take you to court. They could ask for their attorney's fees because you're failing to follow your policy, and for their damages and fines. So it's not great for you to not be following your policy, but please make sure it is up to date. And if you're not sure, like I said, have your attorneys look at it. Just make sure it's all good to go. ADR stands for Alternative Dispute Resolution, which is, I guess, a fancy way of saying some kind of dispute resolution that isn't litigation. There's really only a few things that fall under ADR. Primarily, we're looking at things like mediation. Arbitration is considered a form of ADR. You could have informal discussions that could technically fall under the category of ADR. So what do you need to have in your ADR policy? Not a whole lot. It really, so most associations have a policy that basically says, hey, association encourages dispute of resolutions without litigation. If there's a dispute, we will agree to mediate the dispute with the homeowner if the homeowner wants to do that. But we can't require it, essentially. The only ADR that can be required is anything that is contained in the governing documents themselves. So if the declaration requires mediation before you can file a lawsuit, then it's required. But if it doesn't, then the only thing we can do through the policy is say we are agreeable to doing this. We absolutely cannot mandate arbitration, nor do we want to, because I always say, despite popular belief, arbitration is not cheaper and it's not faster than litigation. In fact, you're paying the arbiter. You don't have to pay a judge, but you have to pay an arbiter to, listen to your case and make a decision. But in arbitration, you know what else you're doing? You're giving up your right to appeal. And that's a big right to give up. There's no reason for that. So again, the ADR policy, it should be simple. You can do it on one page. But again, if you don't have it, you're still technically in violation, and you want to make sure that you do have this in place. Reserve study policy. So this was an addition. Originally, when we had these mandatory policies, we had 7 of them, and that was the infamous SB 100. For those of you who've been around, that was 2005, 2006. And it required 7 policies. It added a couple more later. One of them is the reserve study policy. So the reserve study policy originally was proposed as a requirement that all associations have reserve studies done so that they would know what they need in their reserve account so they could adequately fund that. That was a very scary bill because it also required associations to be fully funded. We've seen that floating around in the last few years as well, fully funded reserve account. Virtually impossible, especially for like condominium communities with all the various elements. However, what we got instead was a requirement that we have a policy on reserve studies. So technically, the statute does not require associations to have a reserve study, but the policy itself has to say when you will have an initial reserve study. And so that implies that, yes, associations need to have reserve studies done. For those who don't maintain anything or don't have common elements, our recommendation is still to have a policy that simply says the association will not have reserve studies because we don't have anything we maintain. And that's fine, but you got to have something. So you need to basically say when your initial reserve study is going to be conducted, or has it already been conducted? How often are you going to update it? How will you update it? Who's going to update it? Are you going to have another reserve specialist come out, an engineer, to do it? Or is the board going to do it kind of on its own? What factors are you going to look at? And then finally, we need to talk about how we are going to fund it. It doesn't have to be extremely detailed, but essentially you need to say, we're going to fund our reserve account through regular assessments. We're going to impose some special assessments. Whatever it is you're going to be doing to fund it, you just want to have a general statement in that policy as to this is how we're going to fund it. Okay, so make sure you have this policy in place. This is the second add-on policy, which is investment of reserves. So we have our reserve account, but are we going to do anything as far as investing it to make our funds grow? There are a lot of associations that dabble in this, that want to invest, and that is okay. However, there's a caveat. You have to be somewhat conservative when you do this. It's akin to the prudent investor rule. First of all, you can't just willy-nilly invest. You've got to consult with an expert who gives you advice. Now, I've had associations that actually had finance experts on the boards, and they were fine acting as a financial advisor, which is, their choice. But at any rate, there needs to be some expert advice given to the board before it starts just investing. And here's the rule of thumb for investments. We obviously don't want to lose money. That's not great. However, if we lose interest that we've earned, it's not great. We can probably live with it. If you start to lose the actual funds themselves, not the interest you've earned on it, that is a liability exposure. Because one can argue that you have breached your fiduciary duty to properly manage the money, because now you are losing the actual reserve funds that we've invested into this account. So again, if you're going to invest, it has to be extremely safe, and you can never ever lose principal. All right. Conduct of meetings. This is another one that I think associations do not use enough. Okay. This is a great tool for associations to run meetings. Unfortunately, people forget about it. And this policy should address both board meetings and homeowner meetings. It should talk about what we expect of people when they are in attendance, how we expect them to behave, what is not acceptable, what is acceptable, how they can be recognized by the chair, when can they talk, what happens then if they don't comply, what if they cut people off, what if they act inappropriately, what if they start, swearing and yelling at people and threatening them, what happens in that case? Well, are we going to kick them out? Are we going to call the police? What are we going to do? And right now, in the day of lots of virtual meetings, it's actually far easier to have control over these types of owners or board members, because if they're on a Zoom, whoever's running that Zoom they have the capability to mute them. They have the capability to kick them out of the meeting. And my recommendation is that you utilize this policy. If it's not right now, you look at it and it doesn't represent kind of what you think it should, the board can amend the policy so that it does adequately represent what is expected of anybody who attends a meeting. And you can have the copies of the policy available if you're having an in-person meeting. You just have copies laying there for people to take and say, hey, read the policy real quick because we are going to be using it today. We're going to follow the policy. We expect everyone to behave in the manner that the policy describes. And if you do follow it, you should have, first of all, hopefully your meetings are faster, quicker. Hopefully you can get everything done and it's less headache. So I very much encourage all of you to pull out the policies, look at the policy, see what it says, make sure it represents the current expectations of the board, and then enforce it. But really enforce it. Don't just say we're going to enforce it. Really enforce it. The other thing that I sometimes see in conduct of meetings policies is action outside of a meeting. How do we do business outside of a meeting? My personal take on that is it really shouldn't be in the policy because this is about how people conduct themselves at meetings. And when you're taking an action outside of a meeting, there is no meeting. But I know that a lot of the policies do have that, and I don't really care if they do have it. I just personally think it's usually addressed in the bylaws, so I don't know that that's something we need to have in a policy or not. Just my own personal thoughts on that. So we're done with the required policies. Take a deep breath. We did it. All right. I want to talk about 5 recommended policies. Now, this is not an exhaustive list by any stretch of the imagination, and it took me a while to figure out which ones I wanted to talk to you about today, because there are so many policies that are recommended. But in the interest of time, it's already 12:37, I want to make sure we have enough time. So I only picked 5, and these are the ones that I think right now are the most pertinent as far as what I'm seeing in the industry. So the first one is claim submission and deductible allocation policy. Essentially, what this policy does is it creates a process where, if a homeowner thinks they have a claim that needs to get filed with the association's insurance carrier, it sets forth the process that owner has to follow in order for the board to make a decision as to whether the claim should be submitted or not. The reason is that many owners nowadays just submit their own claims to the association's carrier. Technically, under Kiowa, they are allowed to do that. Kiowa considers the association's policy the homeowner's policies. They're all additional insureds under the policy. Their money pays for the policy. It's their policy. But at the same time, as I'm sure you all know, if you have 50 homeowners submitting claims for stupid little things, in 1 year, guess who's going to get dropped, right? Or guess whose premium is going to skyrocket to the point that you can't afford it, right? So we do need to have some control over submission of claims to the association's policy, and therefore having this language in a deductible and a claim submission allocation policy is a good thing, because you can then give it to your insurance person and they can know what the process is. So they know if a homeowner just calls them and says, I want to submit a claim, they can say, look, you guys have a process. You got to go through the process. You can't submit a claim right now. The second part of this policy is who pays the deductible. So maybe the association has to submit a claim, but if we have a $10,000 deductible, who pays that? And why is it important to designate that? It's super important because there is a trend right now. And if you talk to your insurance representative, I'm sure they will tell you all about it. But the trend is that homeowners, individual policy carriers, all assume that the association's insurance is primary, which it always is if your community was created after July 1, 1992. Kiowa says it is primary. Even if it was created before that, they still function under that assumption. So the follow through with that assumption is that if it's a claim that's submitted under the association's policy, the association is also required to pay the deductible in that case, because it's our policy, we're primary, we got to pay the deductible, and only after that will the homeowner's policy kick in. That's a problem, and I'm seeing it more and more. And what we can do to prevent that is to have an actual policy that says, here's how deductibles are allocated. There's different ways of doing it. One is you can say whoever has the maintenance obligation outside of insurance will also be responsible for the deductible. You can say if it's work to a unit, it's the owner. If it's common elements, it's the association. If it's a mix of both, it's whatever the percentages are, depending on how much work each one needs. I mean, so there's different ways of doing it, but the point is you do it and you have the policy in place so that if an owner's insurance carrier goes to the association and demands money because they paid a claim out and it's the deductible amount, we can say, no, 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 we have a resolution. Here's how deductibles are allocated. And Kiowa says we can adopt resolutions to that effect. The only time you're not going to be able to shift the deductible to a homeowner is if you have something in your declaration that says the association is responsible for paying all deductibles on its claims. Sometimes, unfortunately, we see that. And then you cannot modify that through a policy. That has to get modified through a declaration amendment. Okay? But the policy is important. The other reason it's important is because there is some kind of broad language in Kiowa that implies if you don't have a deductible policy that the association pays the deductible for claims on its policy. It doesn't flat out say it, but it very much hints at it. And it is very dangerous for that kind of an association to try to push a deductible back against the homeowner if it does not have something in writing that says this is the policy, this is how we do it. So if you don't have one of these policies, talk to your attorney about it. It's super important, especially now. Really important. All right, next one. Retention and destruction of records policy. So, you have to have your inspection of records policy, but this is kind of the flip side, and this is how long do we keep documents, when do we destroy them, and how do we destroy them? Why do we need this? Society is getting more and more litigious. We're seeing more lawsuits filed by homeowners against associations. We're seeing more letters from opposing counsel saying, you better not destroy any records. And if you do, we're going to charge you with exfoliation of evidence and blah, 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 blah. No association needs that. So if you have a policy in place that says it basically will list all the various types of documents, it's fairly lengthy because there's a lot of documents, and it'll say for this document, we keep it this many years, this document this many years. There's some documentation that has to be kept permanently pursuant to the law. There's some that has to be kept like a year. There's some that's 7 years. So it really just depends on what it is. But if you have a specific policy that says this is how long we keep each document, this is when we destroy it and how we destroy it, then you can't be accused of getting rid of evidence because you're just following your policy. So if a year down the road after you've destroyed something, homeowner sues you and they're like, we need copies of this document, and you say, sorry, we've destroyed it based on this policy, and it's written out that we destroy it after a certain amount of time, they can't, they can always accuse you, of course, of trying to hide the evidence, but a court is going to see through that, and they're going to say, no, you followed your policy, you did what you should have done, and this is not you purposely trying to hide evidence from the plaintiff. So again, this is an important policy to have for that very reason. I do encourage boards, if you don't have this policy in place, you should seriously consider getting one drafted for you. Reasonable accommodations modifications policy. So this all goes to accusations of discrimination based on disability. There's been a lot of accusations of discrimination against associations. When it comes to disability, that is a big one. And the best thing you can do as an association to assist the board with managing this is to have a policy in place. And this really goes to the owners who want reasonable accommodations and modifications. I need an assigned parking space close to my front door because I have a disability. I need my emotional assistance turkey because I have emotional issues. So what this policy will do is it'll create that process, first of all, of how do homeowners, or residents request these types of things. It will have a process for how the association investigates it, whether or not we can request that they provide us with a medical provider letter, what that needs to contain. And the benefit of this is it's the consistency. Every time anything happens, anytime someone requests something, we're going to follow this policy to a T. Okay, so first of all, we're not treating different people with different disabilities differently. We have the same process for everyone. Second of all, it helps protect the board because you're not accidentally missing a step, right, as far as something you need. And generally, it helps keep you out of trouble. Now, I'm going to say you should always have attorneys involved when you have a request for an accommodation or modification, even if you have the policy, because right now this is so touch and go and there's so many things out there. There's so much like litigation on it that you really want to be safe and you want to make sure your legal counsel has at least looked at everything and given you a green light to move forward. But the policy is really important to make sure you're consistent throughout the association's existence. Flags and signs. The reason I put this on the list is because I know it still confuses a lot of people based on the questions I get. So a few years back, we had the legislation that again changed what associations can and can't do with respect to flags and signs. So the biggest thing that came out of that is we cannot regulate content. And people have a really hard time reconciling that with our ability in the past to limit political signs, right? Political signs, political flags, and those types of things, and the American flag. So all of that was based on the content. If something is political, we're talking about the content being political. If it's an American flag, we're talking about the content of that flag. So all of that has gone away. We can no longer have different rules for political signs. We can no longer have different rules for US flags. It has to be the same for all, with one exception, and that's commercial signage, commercial flags. That's the only exception. So if we can't regulate content, that means you can't have rules that talk about holiday signs, holiday flags. It doesn't matter. That you all have to treat them the same. We have to allow at least one of each. Okay, so your policy needs to say that. You can allow more than that, but you gotta allow at least one flag, one sign. You can regulate the number. So as long as you allow at least one, you can regulate the size, general placement of them, other non-content based factors, such as I've seen associations have policies that say, no flashing lights on your signs. You can't attach them to a tree. You can't attach them to your fences. They have to be freestanding. Things like that. I've seen different things. We have to allow a mast for a flag. So you should have some language that talks about the mast. So again, you can regulate quite a bit still. You just can't regulate what the sign actually says. and I have had a lot of inquiries, especially last, when we had our election season with people being offended all over the place about people's various political signs. And they wanted to know if they could force signs to be removed because they were offensive. Nope. It can be offensive. It doesn't matter. That's content. We can't regulate based on content. So keep that in mind. If you're struggling with that in your community and you don't have a policy yet, you probably need to have one adopted. Otherwise, you really can't do a whole lot of anything because you're not regulating signs at all, except for what's in your declaration, which may be nothing, or it may be something that conflicts with the law that you can't enforce anyway. So consider. Last but not least, camera policy. So this, more and more people are putting up cameras, and I'm seeing more associations put up cameras. So the policy can address either owner-installed cameras or association-installed cameras, or both, okay? So with the homeowner-installed cameras, what we hear about most is, my neighbor Bob is pointing his camera in my bathroom window. Tell him to stop. This is a violation of privacy. This is this is that. Or Bob's camera is pointed directly at my car. Why does he need to look at my car? That's privacy. So when you're talking about a camera policy with respect to homeowner installed cameras, primarily what we are wanting to regulate is where they put the cameras and where the cameras are pointed. And, that's really essentially all. I mean, I guess you can try to regulate the size, but nowadays cameras can be super small. So I don't know how many people are putting up big cameras. But again, we could regulate where they put them and tell them you can't point it at your neighbors. You can only point it directly in front of your unit, something like that. When associations install cameras, that's a whole different ball of wax. That kind of a policy, we need to talk about, first of all, are cameras monitored? Do they have a live monitor? If not, who views the recordings? Who has access to them? What if a homeowner wants a copy of it? When would we produce it? How long do we keep it? When do we, get rid of it? How do we destroy it? Those types of things. So that's much more aimed at protecting the association from being accused of, you're not giving me documentation I'm entitled to, or these are security cameras and you're not protecting me, and you should be. So two different types of camera policies, but both camera policies. And again, we can do both in one foul swoop if that's what you want. But I think they're important because more people are putting up cameras, and associations I see putting up cameras more as well. So I think those are important things to address through a policy if you are struggling with it. Okay, we got 7 minutes, you guys. This is awesome. 7 minutes for questions. We have quite a bit of questions. All right, let me start with the first one. Do pre-Kiowa communities need all 9 policies in place? Yes, that applies regardless of when your community was created. So you need all 9 policies. The payment arrangements for the $25/18 months, what happens to the balance owed after 18 months? Well, like I said, you can have a balloon payment at the end. You can require a balloon payment paying everything else that's owing. And then if they don't, we're going to collections. What happens if the HOA board has been modifying the covenants and policies for 2 years? I don't know. I think it depends on whether they're doing it correctly or not. Generally when I see boards doing their own modifications, I cringe because when I review them, they are not quite in compliance with the law. Also, with respect to the covenants, that requires homeowner approval. That's not something boards can modify on their own. So my recommendation would be to have all of those looked at by their legal counsel to see kind of where the association is. And what is valid and what isn't valid and what needs to happen to make things valid. That would be my recommendation. If your adoption/revision of policy does not include the notice comment clause, does it meet DORA requirements? Well, DORA doesn't care what's in there, but Kiowa does. And so I would say yes, you need to update that policy because it does not comply with Kiowa, because it does require that we have that information in the policy. So I would recommend getting with legal counsel and modifying it to add that language in there. If a board wants to merely put reserve funds into a money market versus a bank account that earns only minimal interest, what type of expert advice would be required? I would say at a minimum, have a finance person tell you this is okay and this is safe. You won't lose money like this. You may know it to be true, I may know it to be true, but that isn't really going to help us if someone sues and we don't have some sort of an expert opinion. We haven't checked with an expert. So that would just be what I would recommend in that particular case. Can you email me what each policy was? This is all on our website. You are welcome to go to our website and just do a search for required policies. It'll all pop up. All this information is on there. And also, you should have received a copy of the PowerPoint this morning. We sent it out around 8 a.m., a little before that. And it has all the slides. If you didn't get it, shoot me an email. I'll send you a copy of it. Let's see. Regarding policies, can an HOA create a no smoking policy, although the declaration does not allow or restrict smoking? In other words, the deck is silent. You can limit smoking on common elements, including limited common elements. You cannot prohibit smoking inside units through a rule or a policy. That has to be a declaration amendment. Let's see. I have a leak issue from the top unit. Looks like it came from the roof. It affected 3 units. The damage is around $8,000, but the deductible is $25,000. Should the association just repair the damage? It's not worth making a claim. I wouldn't be so quick to do that. I would have your attorney review everything because you may not have an obligation to repair the damage. If the damage is below the deductible, there's no claim submission, which means we have to go back and look really at who has the repair obligation outside of insurance. And so that's a legal analysis. And I would say forward this to your attorney. Don't just spend $8,000 on something that you're not sure if you need to do in the first place. Should management company inform the board of all claims, including injury claims? Should this information be included in the meeting minutes until its conclusion? I mean, I think that you should inform the board. Whether or not it goes in the meeting minutes is going to be up, to the board, and whether or not they want that in the meeting minutes. Let's see, for reserve study policy, is there a good possibility that reserves must be funded to the level suggested by a reserve study? Is there any age of a condo association, like before 1987 or something, that they are not required to have the reserve amount specified in the reserve study? No, I mean, the purpose of the reserve study is to give, it's usually a 5-year plan to an association of anticipated when you are expected to replace the roof, absent insurance, the siding, whatever else the association maintains, and then it gives you a plan for, how much you need to put into your reserve account so that you are at a certain dollar amount as needed. And so it doesn't exempt anyone from anything. So I would say, especially for older communities, because that's really where you're seeing the wear and tear and the need for replacement, I would absolutely encourage everyone to do the reserve study. Let's see. We prohibit real estate signs. Is that permissible? Yes, that is considered a commercial signage, so you can prohibit them. Can you regulate hate signs, for example, a swastika? Unfortunately not. What you can do is you can report it to the city or county and see if they're willing to do anything about it as far as like hate speech goes. But unfortunately, the association, it's still content regulation, and we cannot regulate that, period, end of story. So unfortunately, no. And nobody wants to see that, that's for sure. On the flag, oh, sorry, we're done. Last question. One, on the flag sign content, does this mean that curse words can be allowed? Yeah, so that's the same as before. Anyway, here's my email. If you have questions I have not answered, feel free to shoot me an email. I'll try to get back to you within a few days with my 2 cents. If you have time, please take the survey, and thank you so much for attending today's webinar.